God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
Good morning, Mr. Strigler. Good morning. Good morning. Thank you. Mr. Strigler, you will have 15 minutes. The green light will go on as soon as the clerk turns it on. The yellow light will begin to flash when you have 1 minute left, and when the red light begins to flash, it's time to finish your argument.
All right, I'm a relative novice at this, so if I make any mistakes, it wasn't intentional, it wasn't planned. Excuse me. First of all, I want to address my application. My application was made to the Board of Bar Examiners. I did it in good faith. I did it with sincerity. I did it with candor. The report, according to the Board of Bar Examiners, says it wasn't. Number one, I've had heart surgery in 1998. I had a triple bypass. And after the bypass surgery, a lot of my memory faculties were not all that developed compared to what it was in March of 1998.
Is there a report from your physician that is specific to you in that regard?
Not yet. I mean,
well,
again,
today's the appeal.
I submitted the letter to the board. They didn't even consider it. So,
a letter that was specific to you?
I've never been tested for it. It's not like I had this illness and I said to my cardiologist that, hey, by the way, my memory's not there. I just mentioned it in passing to him a few times. And he said it's a natural occurrence to some people. And in fact, I submitted a research update.
Yeah, but the research update says that the condition subsides in most people after 1 year.
In most people, in some people it stays.
Is there anything that says that in you it has not subsided?
I have not been tested.
Okay.
I have not been tested. I have momentary loss of memory. I will forget names of my own children from time to time. There's nothing I can do about it. I try to keep my mind very active. That's the way I deal with it. I do not deal with it by...
What if you're admitted to the practice of law and forget the statute of limitations or something in a case? What do we do then?
Those are things I can write. Those are things I can write down in a file, just like today. I have everything in writing. So I can memorialize it. And just like Chief Justice, well, not Chief Justice, Supreme Court Justice Alito, he forgot things he did in the 80s. And he doesn't allege to have anything wrong with him. So I think my memory loss can be shown to come from a different source.
Okay.
And meanwhile, the board doesn't believe me. They find me unsuitable to serve. Number two, the GATS Treaty.
Is the GATS a treaty that has been approved by the United States Senate?
Yes, 1994.
Well, the treaty has been approved, but the reach of the treaty to cover legal services is handled somewhat differently than, for example, accounting services.
But it's also involving legal services now.
But that's only an agreement that was entered into by signatories of the World Trade Organization.
It is a treaty.
And the treaty specifically addresses legal services?
Yes, it does. It addresses all services. And in fact, we exported $2.56 billion worth of services. In 2004, we imported $884 million worth of services in 2004, of which none of those were regulated by any state agency anywhere in the country.
You know, your memory's pretty good.
It is. It's selective. It's just unbelievable. I mean, I can remember my first grade teacher, but I can't remember certain things.
I can't.
It's just, it's a challenge.
Mr. Strigler, would you like to move on to the next point after the GATS?
All right, the GATS Treaty was signed in 1994. It was agreed to. It was ratified by the Congress. It was signed by the chief executive at the time. And it says that no state regulation should impede the services traversing borders. Again, because it is a federal treaty, it supersedes any state law. It supersedes any state regulation that impedes the effectiveness of the treaty. The fact is, you have these services coming in from other sources that are absolutely unregulated. So it creates a whole new dynamic to which we as a country must adapt over time. Just like globalization has changed our manufacturing industries, globalization is changing our service sector. And it requires a new thinking, a new way of looking at this. And again, to regulate at local levels, number one, impedes the treaty. Number two, allows local politics to impede the effectiveness of the treaty.
Are you a member of a bar of a foreign country?
I might be very soon.
But are you now? Were you at the time that you applied to the Board of Bar Examiners?
No, sir. But it's not all that difficult to be admitted into a bar in a foreign country right now, especially if you have an American law degree. And then you can go sell services here, be part of that $884 million here without any involvement by the state. And in fact, Judge Cordy recently handed down a decision in another Board of Bar Examiners case. And he cites federal law, state law, and American law. He cited a whole new area of law that I've never seen in any other case in this country. So there's some type of hemispheric law he must have been referring to in addressing the issues in that case. There was a Nigerian fellow that had got a Nigerian legal education, got an education, I believe, in Barbados or Tobago, and then came here, actually passed the New York bar, and then came here to be admitted into Massachusetts. And again, there's an internationalization going on in the field that surpasses any state involvement. Yes, you might have some rights to regulate, but I think extreme rights to regulate, to actually look at this not as a business, supersedes the federal authority. And I think in Crosby, which was the case where the Massachusetts legislature passed a ban on dealing with Burma, the Supreme Court was very clear in that and actually stated that this is not the venue of the state. This is the venue of the federal government. The same thing here. I'm making that assertion that it is absolutely a similar situation to what exists. We are trying to regulate everybody. And the thing is, you're not regulating everybody that's selling services here. You're not. It's a business. It's a monopoly. In fact, in Terrence Holliday's book, Beyond Monopoly, it talks about how 70% of the profession come from people who are affiliated with the profession. That leaves 30% of people entering the profession have no tie, and those 30% are fighting for those seats, despite, in many cases, adversity, challenges, all kinds of issues. That is changing, and rapidly changing. But the other issue I'd like to address is the confrontation issue. Under Wilner was a Supreme Court case in which Wilner was deprived the right to be challenged by his accusers. I believe it was a bar administration hearing. And the court said that where he was being deprived of a livelihood, he should have the right to confront his accusers. I have not been allowed that opportunity by the BBB.
Did you subpoena the witnesses that you knew had been interviewed?
I did not. I relied, again, on an attorney. There were no rules in this organization. There were no, they just make up things as they go. We have a situation where one fellow was told the federal rules of evidence apply to these proceedings. I was told no rules of evidence apply to the proceedings. And I think the lack of transparency impacted my attorney's ability to really prepare properly and argue properly. And I don't know about any other branch of government. I've never seen a branch of government that lacks transparency like that. We have rules of civil procedure. We have rules of court. And yet this organization has no rules. They do whatever they want, whenever they want. And that goes back to the, the issue of really the administration of the BBE. I mean, Chief Justice Marshall had an address to the MBA, I think, Mass Bar Association, in 2005 or 2006, in which he noted Attorney Muldoon's service to the BBE of like 30-odd years, Attorney Barshak's service to the BBE of 34 years. I just think it's remarkable that under Chapter 221, Section 35, it says you're supposed to appoint somebody every year for a one-year term, for a 5-year term, but appoint somebody different every year, and it's the same people. And it seems to me you've created an aristocracy outside of the judiciary, yet they claim they're part of the judiciary. They don't have the same obligation of the judiciary. And I just feel I was deprived of my right. I was deprived of my ability to present a fair case. I was deprived of my ability for a fair process, due process. And I just feel my constitutional rights were violated extremely by this matter. And again, I mean, I wish to appeal to you that I don't come from the best background. Like Prager, my parents were Holocaust survivors. They had a very tough existence. And I didn't come up with, a great environment. I didn't have great things around me. But I've learned. I've learned by life. I've learned by living. I've learned by doing the right thing. I have always involved myself with a lot of people that are worse off than myself because I could be worse off than I am. But my becoming an attorney gives me a chance, and I will work for nothing. I assure you, I will work for nothing to help kids get through life. I've done a lot of research in attachment disorder, and I think this is the problem. It's easy to sit there and judge people as perfectly normal and say, you should represent the norm. But there are people on the fringes that are extremely talented, extremely bright, that we don't bring into the system. And even conditionally, if you let me become a member of the bar, I think I could show what I could do. I mean, we need people desperately in public defender positions. We need people desperately in juvenile justice positions. I'm working with orphans from Uganda. I'm working with the Fair Food Plan. I have no qualms about working for nothing. I've done well in my life, and I will continue to do well. But I'd like to do well for other people and maybe leave this world a better place than when I came. And I guess that's my summation. Thank you.
Thank you, Mr. Strigler. Mr. Muldoon?
Chief Justice Marshall, and may it please the Court, Robert Muldoon for the Board of Bar Examiners. With me is Katie Koski. First thing to be said is that, of course, the question of admission to the bar of Mr. Strigler is your decision, not the Board's decision. The Court has, and particularly on the two most recent cases of this sort, Stransky in 441 Mass and Crone in 443, pointed out that the Board of Bar Examiners, provided it has interviewed and done an investigation, is in a fairly good position to determine the character and attainments issue as the statute imposes the burden on this Court to determine for those who are called to the Bar of Massachusetts. Here, what the Board did was it had two informal interviews with Mr. Crone and others, associates, and I believe his lawyer, Mr. Glotzer, from time to time. That was followed by...
Was Mr. Strigler?
I beg your pardon?
With had two informal...
Two informal
with Mr. Strigler.
conferences, members of the board with Mr. Strigler, as the board customarily does with the small number of character issue cases that come up every year. It starts that way. The second thing that the board did was to appoint Philip Grater as special counsel, and you have his extremely thorough and detailed report on Mr. Strigler's history to the degree it's accessible by records following conversations that Mr. Grater had with various folks, including those who wrote his letters, Mr. Strigler's letters of recommendation. That was followed by a full hearing at which Mr. Strigler was represented by counsel Robert Glotzer. The rules, contrary to what he has said this morning, the rules of the board, which are fundamentally the rules of this court, implemented by rules of the board that this court approves, provides for the acquisition of subpoenas for witnesses, which Mr. Strigler certainly was aware of. He chose not to do that. So the background of the board's activity is that. The board also received extensive submissions from Mr. Strigler, from his lawyer. He requested at the conclusion of the hearing that the record be kept open for submission of further materials, such as affidavits, letters, and the like. And it was in that context that we got the very brief letter from the doctor saying that memory problems could affect persons who have had the surgery that Mr. Strigler has had, but there was no test or report of that. And more tellingly, that issue didn't arise until really the end of the hearing, when he asked permission to submit anything, and we said he should have another month to submit whatever he wished. In a case of this sort, as Your Honors know, the 5 so-called Hiss factors apply. In this case, the board found, with respect to the factor of age, maturity, and experience, that the criminal experience and history of Mr. Strigler starts in 1973, when he was, I believe, 22, and the last criminal matter and civil matter was in 2001. 28 years in which the several actions against him.
What happened to the matter in 2001? That was dismissed.
And 2001 was dismissed. There was followed a civil lawsuit in which he paid Mr. McGrady $10,000. There was an issue, and it's related some in the record, that the car that was at issue somehow had gone missing. But that history comprises Mr. Strigler's life from his 20s to his 50s. The maturity and experience issues are he was educated. He has a degree from the University of Pennsylvania. He has taken courses in various schools over the years. He's had a number of businesses. In the automobile businesses that he ran, he had frequent interactions with the law by way of various issues dealing with cars that might have been stolen, cars that had licenses that may not have been his, license plates rather were not his, things of that nature. If this were just a case of some motor vehicle violations, we wouldn't be here. But the board found that all of these, those particular matters taken together, illustrate a casual approach to the law.
Weren't there also cases of domestic violence?
Yes, I'm coming to that, if Your Honor, please. That's exactly so, and I'll mention those. The cases that he did not report on his application are cases that have really caused the board considerable concern. The first one is the case of Norfolk Probate Court in 1999, in which he held himself out as a cousin of a young woman who was in her early teens to become her temporary guardian. How that arose, he testified in the hearing, and it's at length there, was that a friend of his, a Mrs. McCarthy, who also was one of his 3 character witnesses, had a niece come from another state who was giving her some trouble, and he was then living in Norwood, and they wanted to get the girl into the Norwood school system. So they arranged to apply to have Mr. Strigler appointed as guardian, temporary guardian, for the purpose of enrolling the young woman in the Norwood school system out of the Boston school system. And he represented that he was a cousin, that is to say, a blood relation of the young girl.
I take it once you're appointed the guardian, then the child can go to the public school in which you are a resident, correct?
I'm not certain of that. I suppose it's tied to residence, and if he was a guardian and she lived with him, and it developed that she continued to live in West Roxbury or Roslindale, where the aunt lived, who was the friend of Mr. Strigler, and he lived at that time in Norwood. But the concern that the board had, and it's expressed in the transcript which you have, is that they deliberately misled the court with respect to the relationship for the very obvious reason that a middle-aged man seeking a guardianship over an unrelated young girl might raise a question in the eyes of the court. So it was done in order to, I believe, and not I, the board believes, was to mislead the court into allowing something on the basis of a blood relationship. And the purpose of it was to have the young woman go to school in Norwood, which we understand she did at a time. A second case that's very serious, and you'll note that there are a small number of 209A applications against him, is the so-called the Jacobs case, which rose to the question of intimidation and application for 209A by his friend Ms. Jacobs. The Holt matter, which led to the breaking and entering and I believe assault matters, is also laid out in the board's report, in which it's fairly clear to the board, and they found this, that just as he was subject to being involved in a number of litigations involving his business, so also his relationships with women over the years have been marked by turmoil, aggravation, intimidation, fear, issuance of criminal complaints, issuance of 209As. In the Bruno matter, Lisa Bruno, which is laid out in the board's report, you'll find there the situation of a woman who became pregnant by him, issues of his desire to have her obtain an abortion, an extremely difficult situation in which, as to which he testified that he became very concerned himself because he felt that persons, and I think he mentions the North End, were out for him, and he volunteered that he has been himself the subject of several attempts at being murdered. All of this history, each case taken individually, might not be sufficient to warrant a recommendation of non-qualification. Taken collectively, and certainly Crone tells us that it is the collective observation and conclusions on what might be called the outward and visible signs of a person's inner disposition that leads to a question of whether or not a candidate for admission has the character and attainments which the court requires before issuing the general license to practice law.
Mr. Muldoon, this
Yes.
may not be directly relevant here, and forgive me if I am proceeding in ignorance. Does the board have anywhere articulated standards for its fitness and moral character determinations? I mean, do you lay out?
Not per se. We have, I think, the quartet of cases, Hiss, Prager, Stransky, and Crone.
Sure.
I think cover the ground in all of this, and the Hiss factors are well known.
Sure. I suppose I could ask the question differently. The BBE maintains a website. If one went to it, if you were somebody, the person seeking admission generally has not practiced law elsewhere, although sometimes that's not the case. Is there a place where you can say, look, go and look at those 4 cases and you'll pretty well get the lay of the land?
I don't know the answer to that question,
Sure.
whether it was or is now on the board's website.
That might be helpful to tell people.
Indeed.
In part because it'll, I think, help the board.
Generally speaking, this is a very small number of cases. Every year there may well be before the board as many as 12 or 15 character cases, 2 or 3 or 4 of which may result in hearings. And generally speaking, over the years, I think the board has found that the the cases are fairly well known, but so far as articulated standards, that would be something that would have to be approved by the court, obviously, as
Sure.
Board rules. I think the
In practice, how does it work? If in some sense there are no formal rules, but there is this quartet of cases, has anyone, to your knowledge, ever complained that the board has denied them the opportunity to present evidence of good character?
not until this case.
Mr. Strigler knew about this in advance, did he not? He knew you had gathered all this information?
Yes, and he had the
And he
report.
was given a reasonable opportunity to rebut it?
Yes, and the report, Mr. Grader's report, which is in the appendix, is quite clear as to the standards that are applied, and they draw obviously from the tradition of the court in those cases.
Yeah,
So
I
any
knew-
applicant is aware of the standards as drawn from those cases by virtue, and this is customary, that special counsel, when they do that, we have over the years developed the process of having
Yeah, and-
the introduction to the report state the standards, and then the results of the
And
investigation.
your proceedings are not trial-type proceedings. They're more or less administrative in nature, and long as the person is given the opportunity to rebut or explain, as the case may be, in this case, rebut and explain,
That is correct, Your Honor,
that would seem to
please.
satisfy any kind of
This is a,
process concern.
as the court noted in the Prager case, this is not an adversarial proceeding. We act as agents of the court and assisting the court to come to an opinion as to somebody's character. It's not an easy task to do that in any context, including this one.
I take it, Mr. Muldoon, that the board's recommendation with respect to this, I mean, the standard relates to present fitness to practice law.
Yes.
So the recommendation is that he is not presently fit to practice law.
Yes.
So
And
that doesn't preclude another application several years down the road.
there is no prohibition on as many applications.
Is there
as
a
one
time
wishes to do.
period?
Nope.
No.
Completely open.
Mr. Meld, I go back to the notice because I think that one of the things that the board is, and I think the cases hold it pretty clear on, is full disclosure. Now, obviously, undertaking to study for a JD and the expense involved, somebody should know beforehand, and there's no reason why they shouldn't know, that you're going to have full disclosure, and a lot of people may or may not want to be examined on that basis.
That's correct.
And so, I mean, there's nothing that has always been central to the fitness and character check of the board. I mean, at very minimum, it has to be full disclosure, correct?
The candor on the application is, in fact, that is so important that failure to be candid on an application, if someone gets admitted under Rule 8.1 of the Massachusetts Rules of Professional Conduct, is a basis for very severe discipline of an admitted attorney who has not been candid. That's the only part of the rules which relates to someone who was not an admitted lawyer at the time.
In a sense, the obligation to sort of pre-screen folks who might have this kind of trouble lies with the law schools, doesn't it? I mean, you don't know who these folks are until they actually graduate, and then they pass the bar and apply for admission. So if someone down the road is going to have an awful lot of trouble, the law school, it would seem to me, has got to call them aside before they admit them or after they admit them and say, hey, look, you may go through and get your degree, but you may have a lot of trouble with the bar examiners.
Right. If I may, on the law schools, that's the relationship with the law schools is as it is, and what they tell the board and what they don't. But on Mr. Justice Cordy's question on current status, the board conclude that the lack of candor on the application, the lack of candor through the process, and particularly in the hearing, where some of his explanations for some of these events, including the Norfolk probate case, including the other cases, was, as was found in Crone, unworthy of belief, right down, again as in Crone, to the submissions to this court, the single justice in this court. Not a word of anything about his own character in his submissions here. All are attacks on indeed the authority of this court, even to be sitting here today. All of these diversionary tactics, consistent with his practice throughout his career, it seems, of blaming everybody else for his troubles, assistant DAs, bad judges in the divorce, vindictive state troopers, equally vindictive state folks, his lawyer in the hearing before us. His arguments, which are somewhat over the top with respect to the board, he accuses us of seeking for preposterous lies in order to bar people from the admission to the bar. All of these things indicate that the current status of his character, so far as we can divine it, is that it should encourage the court not to call him to the bar of the Commonwealth, and so the Board of Bar Examiner requests.
Thank you, Mr. Muldoon. Thank you, Mr. Strigler.